Stock and Avowed, file 22-10637-CZ. Counsel, you want to put your appearances on the record, please?
Thomas Levin on behalf of the plaintiff.
David Spangros on behalf of the defendant, and it is the defendant's motion today, Your Honor.
Go ahead, sir.
Noting the court's docket today and that it has read the briefs. The only thing I want to point out is that we do have a trial next week, I'm sorry. And what I want to do is bring a little focus into this matter and what we're dealing with as a very odd trust. I've been doing trust for about 35 years, and I don't think I've ever seen one quite like this.
I'm glad it's not just me then.
Yeah, it's and I didn't do this trust. I want to point that out too. I had nothing. I don't believe Mr. Levin did either. So what I want to point out is that the agreement is basically with himself, and we're dealing with a situation where it's his money, and built into this is a waiver of the beneficiary, the late Suzanne Stock, to receiving any accountings or any review of the trust, including the compensation. So I believe that the statutes that were cited in the motion are applicable, and that at a minimum, the issue should be limited to compensation taken by the trustee from December 31st of the year prior to her death, which was 2020. And just as a side note, I looked at the date that this was filed. It was 2022, and I think I had hair when this case started. So it's been dragging on, and hopefully it's got to be finished here. I think in some ways, I think we might even been limited by COVID. It's that old. So I would ask the court to review the trust, the statute cited, and the way that it is set up, and grant the motion and limit this trial to the amounts stated in the motion, Your Honor.
At the time, and I'll give Mr. Levin a chance to respond in just a minute, but Mr. Svengros, at the time that the trust was written, the beneficiary was limited to the mother, Suzanne Stock, at that time. Is that correct?
That is correct.
So after her death, then we have these remainder beneficiaries. Is that correct?
We have one remainder beneficiary, and that is the Suzanne Stock Revocable Trust.
And is that some of my difficulty is not knowing all of the family players. Is there a Suzanne mother and a Suzanne daughter, or is it just two different revocable trusts?
It's two. Well, the trust at issue in this case is an irrevocable trust. And then the beneficiary of the irrevocable trust is a revocable trust, which became irrevocable upon Suzanne Stock's death. So Suzanne Stock is dead.
There's not two Suzanne Stocks.
There is not. There is just one. And she is deceased.
Trusts. All right. And she's now deceased. And she was the beneficiary. The person was the beneficiary of the first trust.
The irrevocable trust at issue, yes. She was the beneficiary during that time.
All right. And then once she passed, the second trust became the beneficiary at that time. So all right. Thank you.
All the money from this trust flowed into that one.
Thank you. All right. Mr. Levin, your response?
Your Honor, I think the motion should be denied for about 3 or 4 reasons. Number one, I had mentioned a scheduling order, and the scheduling order basically said in this case that motions in limine should be brought, it should be heard 14 days prior to January 7th, 2026. And of course, it's not being brought at that time or heard, and therefore I think the motion should be denied based upon that. Second of all,
hang on. Let me stop you right there, because you're going to give me about 4 different reasons, and then I'm going to lose track of them all. So the scheduling order violation, what prejudice do you have if I allow that to go forward?
Well, at this point in time, he's asking for certain testimony and to be denied based upon this new motion. And in terms of being prejudiced, I think I should know beforehand. I think the motion was filed sometime in May, and I think it's too soon. There's not enough room there, not enough time for me to make readjustments, etc. I mean, I relied on the court order, and if the court may recollect, Mr. Svengros, under that court order, the witness and exhibit list was supposed to be exchanged 30 days prior to, I think, January 7th. It wasn't. And the court sanctioned Mr. Svengros, the defense, by striking 2 witnesses off of his list. It's the same scheduling order. And I guess I'm under the belief that once a court issues its order, it issues its order. If Mr. Svengros wanted to go ahead and change the timing, he could have at least brought a motion to amend. He didn't do that. So, you know, we're having a hearing today, 1 week.
Mr. Levin?
Yes.
My question was,
yes,
what prejudice to you if I allow this to occur?
Well, if you allow the motion to, if you were to grant the motion, it would cut off almost half of what we say is a wrongful taking of money. But that's just based on the scheduling order. So that's what the prejudice is.
That's not a prejudice. That's the result of the determination of what is appropriate. That's not a prejudice. The prejudice would be, well, I've got witnesses available and now they're not going to be available, or I don't have time to respond to certain things. The outcome is not a prejudice. It's the process that would be the prejudice. So what process prejudice would occur if I hear this admittedly late motion?
Well, I would have to go over the situation with my client based upon your determination. And that's where I see the prejudice would be. We wouldn't be able to, we may have to bring in other witnesses or whatever the case may be. This, although was raised as an affirmative defense, had never come up before except in the last month. And I don't know whether I need additional witnesses or anything to that extent. I thought things were finalized back in January, and that's what it was. The defense did not bring a motion at that time for limine, and it was already on the scheduling order. So why this late, coming close to what appears we're going to have a trial next week? And I may want to respond with other witnesses.
I would assume that you would have all of your witnesses already ready. That was the point of having the witness list and the exhibit list, right?
Well, I didn't consider.
The only question is, are we going to cut the list and for the time limits? That's what he's saying, that the time limits should be changed, so you would already have all of your witnesses for the old time and going into the future to now time. So all he's saying is we should chop the back end off.
Well, that goes to the liability of his client. But I think.
But it doesn't change your presentation. It just chops off part of it, the oldest part of it. So all of your
Well,
witnesses
if he,
would have and should have been already ready.
well, this would not have been an issue, but the point is that his client basically has the information. But I want to get to the point that he's saying cut off certain testimony, which I think the court would need to make a determination as to whether or not uh, uh, any testimony should be cut off, because it's going to have to make a determination as a matter of law, I think, in terms of whether the statute of limitations comes into play for half or maybe more of the claim.
And that's what he's asking me to do, is determine that there's a statute of limitations that applies.
Yes, yes, I understand that.
So why
Well,
would that be?
he's
Why
asking
would
to
that
cut
be?
off testimony. He's asking to cut off testimony. Yeah,
That's
on
what a
the
statute of
premise that
limitations
the statute of
does.
limitations is,
Isn't that what a statute of limitations
yes,
does? So it's really not
yes,
a
but he,
witness issue. It's a legal issue. And isn't he allowed to bring up a legal issue at almost any time?
no, he didn't bring a motion for partial summary disposition. He'd already had two motions prior on summary disposition, and they were denied both times. He didn't bring it. So he brings this motion limiting testimony. So in effect, it is a motion for partial disposition, because therefore we can't bring any testimony to support the claim. So I think it's just, going around thing. That's all. But in terms of the scheduling order, I'm going to rely upon, I'm in the belief that I'm relying upon what a court judge, and this is what your order was. It was already used in terms of sending him on his witness list. It was the same
All right.
scheduling order.
Thank you, Mr. Levin. I interrupted you on your way
Can I
to
go?
giving me many more reasons to deny, so go ahead and continue.
Correct. Yeah, he raises, in terms of, now these statute of limitations are within the trust code, Michigan trust code, and he raises the basis of the statute of limitations he wants to use to the effect.
Looks like we lost Mr. Levin. Mr. Levin, can you still hear me?
Alternatively, we could deal with it next Wednesday. Oh, there he is.
We lost you for a moment, Mr. Levin. Can you hear me?
I should say, Your Honor, that there's a tendency with this cell phone to disconnect me. I'm blaming it on a cell phone. I don't know if it's anything else, because I was on like a half hour ago and it disconnected a couple of times. But I'll go back to your question.
Talk fast.
Yeah. Okay. Did you have a question, or am I continuing?
You're continuing.
Okay. In any event, he brings up this issue about a waiver, and the basis of the statute of limitation that he uses is based upon a waiver to the effect that my client or Suzanne or the beneficiary, the trust beneficiary, remainder trust, basically waived their right to get reports and accounts from the trustee. The trustee normally has an obligation to give an annual report of the condition of the trust, including transactions, etc. And that can be overwritten by the trust document, which was done in this case by Mr. Stock, who was the settler of the trust and also the trustee. And he excused, I'm using the word excused, himself from issuing such a those reports. Now, I'm going to jump ahead. But my client never gave any waiver at all. A waiver under the Michigan Trust Code requires something in writing to be signed by the person who's in effect giving up his right or her right to get the document. So in a case where somebody's supposed to get a document is waiving off from getting it, it has to be in writing. And there is nothing in writing. And Mr. Svengos has no evidence in his motion to support such a waiver. There was no such waiver. And what he's saying is a waiver is the excuse that his client, as settler and as trustee, that the fact that the settler excused the trustee from giving such a way, not requiring it to go ahead and issue those reports, that became a waiver on behalf of my client. My client never signed, nobody signed from the remainder trust, signed the trust agreement at all. There was nothing whatsoever. Now, in general speaking, under general Michigan law involving waiver, that requires an affirmative act. It's got to be intentional, and it's got to be very specific that, in fact, it's being waived, and there is no such document, and there was no such waiver. And therefore, the statute of limitations paragraph that he used with 79051B is not applicable to the situation, and it cannot be used that way.
All right, let me ask you a question then about that claim. Who is your client?
My client is Sandra About.
And how is she related to this case?
She's
the successor trustee. So she's
the
in the
trustee of the
of which trust?
Of the revocable trust, which
Well,
became
I'm not going to
irrevocable.
I'm not going to understand which one that is. I got trust number one, which is what was originally started, and the settler and the trustee were the same person, and then that was for the benefit of Suzanne. And now there is a second trust, which basically is the funds from the first trust have poured into. Am I accurate so far, Mr. Levin?
Well, that's correct. Pour it over. But
right.
that's
Well,
it's partially not correct, Your Honor.
What's not correct?
Well, here's how I want to phrase it. There's this terminology called qualified trust beneficiaries. And both Suzanne was getting, or could have gotten distribution, and the trust, which is now Sandra Abode as successor trustee, is now trustee of that particular trust. That's the pour over trust, if you want to use it that way. They were both, to me, qualified beneficiaries. Therefore, they were both entitled to get reports, even while Suzanne was alive, and have standing to bring suit. And there's a difference between a qualified trust and a beneficiary and a non-qualified trust beneficiary. My client, the remainder trust, was a qualified trust beneficiary because on the death of Suzanne, they were entitled to get the pour over.
But not until, right?
Therefore,
not until the death.
No, but that's not required under the qualified trust definition, and therefore it doesn't pour over until then. But they are still considered as qualified trust beneficiaries and were entitled to get a copy of the documents, which under Article 11 of the trust of the original of the trust agreement, of the irrevocable trust agreement, that was written over. In any event, just so you understand, Suzanne Stock was a beneficiary for distribution under the first trust, and she was also the trustee of the second trust at the same time. So in any event, either one of them were entitled to get reports, except they were written over. Now, under the statute of limitations provisions.
Hey.
Yeah.
If we're going to have a conversation, you got to stop talking when I want to ask a question. You keep telling me that they qualify. Where is that? Show me where that comes from. I'm stuck on Suzanne was the beneficiary. Stanley wrote the first trust and was the settler and was the trustee of it. I don't see your clients coming into this until Suzanne died, and then they have the right to, I agree with you. They didn't sign a waiver at that point, but I don't see them being involved in this until Suzanne died. Why is that not correct?
Well, because they were qualified trust beneficiaries before she died.
Tell me where that comes from.
And they were entitled to get reports.
Tell me where that comes from. What authority do you have for that? I'm sorry, Mr. Levin, you keep talking over me.
I'm giving you the
statute. What you're
statute.
saying. You're doing it again. You're talking over me, and I can't hear you when you're talking over me. So let me ask my questions, and then please give me a good response. So my question is, what is the authority for your claim that they had standing, if you will, prior to Suzanne's death?
I'm going to give you the section, Your Honor. It's under MCL 700.7103. That's in the definitions, and that's 700.7103, small g in parentheses.
All right, let me pull that up. So why is the second trust a qualified trust beneficiary before the date of Suzanne's death? Because it talks about the trust beneficiary, which would be the second trust. You're doing it again, Mr. Levin. You're talking over me. G1A.
I'm sorry, Your Honor. I'm trying to.
I know it, and that's why we're not in person. It's a little more difficult. So just give me a little bit of grace while I'm talking to get it out. So G1A says the trust beneficiary is a distributee or permissible distributee of trust income or principal. That would not be true while Suzanne was alive. Subsection B says the trust beneficiary would be a distributee or permissible distributee of trust income or principal if the interests of the distributees under the trust described in subparagraph A terminated on that date without causing the trust to terminate. That didn't happen. Subsection C says the trust beneficiary would be a distributee or permissible distributee of trust income or principal if the trust terminated on that date. And the trust, while she was alive, the first trust did not terminate. So what am I missing about your client, the second trust, the trustee of the second trust, not being a qualified trust beneficiary before Suzanne died?
May I speak?
Yes, please, go ahead.
Your Honor?
Yes, go ahead.
G2 says the trust beneficiary would be a distributee or permissible distributee if the interest of the distributees under the trust described in paragraph 1 terminated on it without causing the trust to terminate. That's what makes them the second trust would be a distributee without causing the trust to terminate. This is an irrevocable trust. In an irrevocable trust, there are three different ways of doing it, and it requires unanimity of possible court order. It doesn't terminate on its own. So this says, with the way I understand it, this says that the second trust would be a distributee if Suzanne died and if the interest of the distributee under the trust described in one terminated on that day without causing. Her interest would terminate, but they would still be around.
I'm looking for the language that you're reading to me, and I'm not finding it. Where are you looking at? I'm looking at G, subparagraph 2, the two little I's, which starts out, if on the date a trust beneficiary's qualification is determined. Is that where you want me to start?
Looks like we lost him again.
I think he's gone again.
I'm sorry, Aaron.
It's all right.
I think it's probably going to happen. Should I go through my other, or are we going to stay on this issue?
Well, here's my last question for you on this issue. MCL 700.7103 subsection G2 says, if on the date a trust beneficiary's qualification is determined, there is no trust beneficiary described in subparagraph 1. And I think that's where we're at. The question I have is, isn't the date upon which your client, her trust beneficiary qualification would be determined, is the date of death of Susan Stock? Because that's when their interest would start, in my mind.
No, actually, because Suzanne was also the trustee of the second trust at the time that she was the primary beneficiary under the irrevocable trust. Trust
But
number one.
She's not the trustee of the first trust.
Yep. Well, no, she's a beneficiary.
She is a beneficiary, but that just because she happens to be a beneficiary happens to be a trustee of another trust doesn't give that second trust any connection to the first trust until she dies. Then it becomes applicable. So that would be the qualification date.
I don't read it that way. Well, I don't want to step over it. I have to give you time, man.
All right. Give me any other reasons that you have
My
for denying.
Yeah.
Mr. Levin, any other
Yeah.
reasons to deny the motion? Go ahead.
I'm going through my notes, Your Honor, and I'm ready to talk if I can make those statements.
Go ahead.
Okay. With regard to, as I say, with regard to Article 9 of the irrevocable trust, this was set up by Mr. Stock, basically to prevent, not requiring to issue any reports, and he basically, we never received any reports from him. And the first time we received any report was from the brokerage firm, which when I subpoenaed the brokerage statements for the years 2018, 2019, 2020, 2021, basically, that was the first time we received any information concerning transactions involving what was going on in the irrevocable trust. Now, the rule is that the statute of limitations does not run against a beneficiary until such time as they've received reports. And I cited in my brief or answer the paragraph written by Mark Hayter, who was one of the reporter for the Michigan Trust Code draft committee, and so basically says that until such time as the beneficiary gets the reports, basically he says if the trust agreement excuses the trustee from issuing reports and he doesn't issue reports, the statute of limitations does not, he doesn't get the benefit of the 1 year statute of limitations. You have to go to the longer statute of limitations of 5 years. 5 years basically from the time that you get the reports. And in this case, we got the reports in April of 2022 and filed the case in September of 2022. So we were within not only 5 years, we were within 1 year of getting the reports. And that basically, this Michigan Trust Code is taken off of the Uniform Trust Code, which is prepared by the Uniform National Committee. And the reporter regarding that committee basically says that, and the statute is a little bit broader even in the Uniform Code, the National Code. And the reporter says even if the beneficiary actually gave a waiver, there's no right to go ahead, and the statute would not run until they actually got copies of reports. But in our case, it's a little bit different in terms of it specifically says, or the reader, Mark Hayter says, if there are no reports, the statute of limitations does not commence. And I think the other, in terms of the waiver, I've already touched base on. And I'll just touch base about what we talked about in terms of 1B. There wasn't, Trustee was in existence at the time, and Suzanne Stock was the trustee at the time. And I don't want to regurgitate anything. My understanding is that while Suzanne was alive, both she personally as well as the second trust were qualified trust beneficiaries entitled to get reports. Thank you, Your Honor.
Mr. Sven-Gross, any rebuttal or follow-up?
Going back to the point that the court was making, I think the key to remember is until Suzanne's death, that revocable trust could be changed. She could name anybody to be the beneficiary, not necessarily this revocable trust. She could get rid of the trust. She could give it to charity. She could do whatever she wants. So I think the court is correct in the line of thinking that up until Suzanne's death, they are not a qualified trust beneficiary. With that said, the trust is pretty clear. Again, I didn't draft this thing, and I don't know why Suzanne Stock didn't sign this thing, but it says that he does not have to provide any accountings until the death of the settlor, which is Stanley stock, doesn't have to provide it for Suzanne stock. And I think the court should know that this trust was drafted by an attorney for Suzanne stock. So he didn't have to provide reports. But the section that Mr. Levin's reporting to, first of all, this is, I don't know if this is authority, the notes that are attached to the trust code, because it's now called EPIC. But certainly the court can override a trust agreement and require a settlor to provide accounts. That didn't occur in this case. That's not the situation that we're dealing with. So I don't believe that section applies. And it says that nonetheless, some beneficiaries will agree to waive their right to receive accounts, which they did in this case, which ensures that a beneficiary cannot waive the right to receive the account and exploit their own waiver to extend the statute of limitations. So what I'm saying is that in this case, my client operated under this trust for a period of time while his mother was alive with no objection from her whatsoever in regards to the compensation. And the trust clearly provides him the ability to receive compensation. And then what ends up happening is Mr. Levin's client, essentially in the months before his 97-year-old mother died, got her to change her trust to exclude Stanley and her to get all the money. And now she wants even more. But I think that the statute of limitations should at least limit it to that period of time that is set forth in our motion, Your Honor.
Thank you. All right. I'm
Your
going to,
Honor, may I make one final, so may I make one final statement?
go ahead, sir.
On page 513 of the book, the States and Protected Individual Code with the Reporter's Commentary, February 2022 update. The reporter says this, it's on page 513, in terms of the definitions. The MTC uses the term qualified trust beneficiary, and the UTC uses the term qualified beneficiary, but the terms are described similarly. I want to go down to the next paragraph. Before April 1st, 2010, EPIC contained a definition of an interested trust beneficiary that is similar to the MTC definition of qualified trust beneficiary. Both definitions include current beneficiaries, first line remaindermen, and terminal remaindermen. They're all included. And that's in the reporter's remarks page.
I don't think I've ever had this happen before.
Well, you're lucky.
That's true. I was watching your earlier hearing and it's just, I admire your patience.
Something you never want to pray for.
Yeah.
Good to see you again, Mr. Levin.
I'm sorry.
I said it's good to see you again.
Thank you. Should I just use a telephone instead of, would that be better? Or
I think you're going to have to invest in a Zoom account so that we can keep you on a little bit longer and do so through your computer.
well, I don't do telephone normally. I moved my office to internet installed on Thursday, so that's what. I don't know if you heard what I said. If I'll just read the sentence again if I can.
Go ahead.
Before April 1st, 2010, EPIC contained
I haven't heard anything that you've said, Mr. Levin.
Okay, I'm gonna read from the reporter's statement, one sentence. Before April 10th, EPIC contained a definition of an interested trust beneficiary that is similar to the MTC definition of qualified trust beneficiary. Both definitions include current beneficiaries, first line remainder men, terminal remainder. There, 513 of the Epic book with the 2022 update. What the report is saying is that the definition includes everybody, and they were entitled to get reports, etc.
One question for both counsel. Is the second trust listed as a beneficiary in the first trust?
Yes. Judge, I'll point it out to you. It's in, there's a section, Article 5, titled Trust for Mother. Section D, Distribution on Death of Mother. Upon the death of my mother, Suzanne Helen Stock, the trustee shall, after making the above payments, distribute the remainder of the trust assets, including any accumulated income, to the trustee of the Lawrence J. Stock II and Suzanne W. Stock Revocable Trust dated April 13th, 2004, as amended or restated, to be distributed pursuant to the terms of that trust agreement. Again, that's a revocable trust, not an irrevocable trust. So,
Well, yeah, the second one becomes irrevocable on the death of Suzanne.
just as the court pointed out.
All right, as to the issues raised by Mr. Levin, I do not find, for denial of the motion, I do not find that there's been any prejudice to allow the Mr. Svengro's motion. So that's why we've considered it today. As to whether or not there was a waiver and whether or not there was a statute of limitations that was applicable, I find this to be a very close question. In the materials provided by Mr. Levin in Exhibit 2, I believe Mr. Svengos was reading from it. It's Article 7 of the Michigan Trust Code, page 695. And I believe Mr. Svengros read a portion of that. But there is the first full paragraph, the second paragraph on the page starts out subsection 3 is UTC subsection 813 subparagraph C, says that the terms of the trust can prevail over the requirements of this paragraph. However, if the trust instrument excuses a trustee from the duty to account to the beneficiaries, and that was done in this case, and the trustee does not account, the trustee will not derive the benefit of the shorter period of limitations provided in MCL 700.79051, which is what Mr. Svengros is arguing should occur, unless the representation rules otherwise bind persons receiving the account. That seems to say to me, and that's why I asked my last question, that seems to say to me that the beneficiaries, and that's Mr. Levin's argument, is that the second trust qualifies as a, in his words, remainderman, even though they're not actually beneficiaries until the time that Suzanne passes. They don't automatically become the interest or the actual beneficiaries until that comes. And to Mr. Svengros's point, that could have been changed at any time up until. However, the trustee had notice that there were potential beneficiaries, remaindermen, if you will. And Mr. Levin has read me a section that says that the reporters say that those are qualified trust beneficiaries under MCL 700.7103. I was leaning at the beginning of this argument, I was leaning towards saying that they were not, that the second trust beneficiaries, or the plaintiffs in this case, were not qualified trust beneficiaries under 700.7103. And therefore, there would be a statute of limitations problem like Mr. Svengros is arguing. However, after listening to Mr. Levin and his last quote from page 513 of the trust code, I'm beginning to change my mind. Let me go back to 700.7103 G2, which says that if on the date a trust beneficiary's qualification is determined, there is no trust beneficiary described in subparagraph 1, and we've already gone through that. There is none. A trust beneficiary to whom one or more of the following apply on the date the trust beneficiary's qualification is determined. A, the trust beneficiary is a distributee or permissible distributee of a trust income or principal. The trust beneficiary in this case would be the plaintiffs, and they would have been a permissible distributee at the time of Susan's passing. So paragraph B, the trust beneficiary would be a distributee or permissible distributee of trust income or principal if the interests of the distributees and the trust described in subparagraph A terminated on that date without causing, that doesn't apply. And C, the trust beneficiary would be a distributee or permissible distributee of trust income or principal if the trust terminated on that date, and that does not apply as well. So G2 appears to say to me that the trust beneficiary they would be a permissible distributee of trust income or principal, which would make them a qualified trust beneficiary, which means that the 5-year statute of limitations would apply as opposed to the 1-year statute of limitations that Mr. Svengros is advocating for. So I'm going to allow full 5 years back from the date of death, because my view is that statute 77103 applies under G2A, and that the plaintiffs are permissible distributees of the trust both at the date of death and prior to that, because that information was written into the first trust, and it is as Mr. Svengros read to me just briefly previously. So Mr. Levin, would you prepare a proposed order that simply says that as to the motion filed by Mr. Svengros, it is denied for the reasons stated on the record, and the proofs will allow up to 5 years of information from the date of death of Suzanne Stock?
Yeah, could I get one clarification from you?
Okay.
You said, is it G lowercase I-I-B that you're
Yes.
referring to? Okay.
G
Lowercase
lowercase I-I-A.
I-I-A or
Yes.
I-I-B?
A.
Is a distributee or permissible distributee of trust income or principal. Okay. Because I thought you were talking about would be a distributee income if the interests of the distributees under the trust described in paragraph A terminate on that date without causing the trust to terminate.
No, I didn't use B or
Okay.
C. I read those, but I found those to not be applicable. So
Okay.
subparagraph G, II, subparagraph II, subparagraph A, I find that the plaintiffs are a permissible distributee of trust income or principal because they were listed
Gotcha.
as in the original trust. So
Understood.
the 5-year statute of limitations applies. Mr. Levin, will you be able to provide me with that order within the next day or so?
Yes, I will, Your Honor.
All right.
Thank
Does
you
that
for your
resolve?
time.
Does that
Thank
resolve
you.
today's issues?
We'll see you next week.
All right.
Thank you, Your Honor. Bye.
And is that in person? I believe it is it not?
It's in
Yes,
person.
it's in person.
Good, because I don't want to go through this again.
No. Thank you.
Okay.
Thank you. I'll see everybody next Wednesday.
Thank you.